So the ATF's pistol brace rule now faces a nationwide injunction after the recent Fifth Circuit decision. So let's talk about this. But really quick before we jump into this video, if you think the ATF's pistol brace rule is clearly invalid and needs to be struck down, go ahead and hit that like button and subscribe. Also want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are huge Second Amendment supporters. If you purchase one of their dedicated roasts for FBC or GOA, some of those proceeds go directly to those organizations so they can file lawsuits like this one that we're talking about. So again, if you want to support a Second Amendment company and also get great coffee, check out Blackout Coffee using the links down below. And if you use the code ARMSCHOLAR, you can get 10% off of your order. Also want to mention that we have channel merch available. If you're not aware, you can purchase them using the link down below. You can purchase this shirt in this black color, gray color, and then we have another design as well. And actually, we just got patches available. So if you want an ARMSCHOLAR patch, a text, history, and tradition patch, you can pick that up using the link down below. So like I mentioned in the intro, in this video, I have an update for you on the ATF pistol brace case, which is currently pending before a lower court. If you don't recall, recently we received a decision from the Fifth Circuit Court of Appeals, and that was against the ATF's pistol brace rule. Recently, the Fifth Circuit found that in the Mock v. Garland case, that the district court was incorrect in denying the plaintiff's original request for a motion for preliminary injunction. The Fifth Circuit Court of Appeals then sent the case back down to the lower court to Judge Reed O'Connor to issue a new decision on that injunction, and that decision on the injunction needs to be issued within the next 60 days. This was a big win for the Pro 2A side and also signals the beginning of the end for the ATF's current rule against pistol braces. Now that that case is back down in the hands of the lower court, the plaintiffs have submitted their supplemental brief on the remaining injunction factors that are pending before the lower court, and they are currently also asking for Judge O'Connor to grant a nationwide injunction. Now, originally in the Mock v. Garland case, the federal district court judge, Judge Reed O'Connor, denied a request for a preliminary injunction. In that decision, Judge O'Connor stated that the court holds that plaintiffs have not carried their burden to demonstrate their substantial likelihood of success on the merits of any of their claims, and therefore denies plaintiffs' motion for preliminary injunctive relief or, in the alternative, for postponement of the final rule's effective date. Now, after that decision, FBC did file an interlocutory appeal up to the Fifth Circuit Court of Appeals. In the appeal, they challenged whether or not Judge O'Connor abused his discretion and was ultimately wrong in denying their original request for that injunction. The Fifth Circuit then granted review to the case. It was an expedited review. They held a hearing and then issued a decision. And what they ultimately found primarily was that plaintiffs should have been granted an injunction under their APA claims. The Fifth Circuit stated that we move on the plaintiff's claim that the final rule violates the APA's procedural and substantive requirements. On that front, plaintiffs establish a substantial likelihood of success on the merits. The ATF incorrectly maintains that the final rule is merely interpretive, not legislative, and thus not subject to the logical outgrowth test. The final rule affects individual rights, speaks with the force of law, and significantly implicates private interests. Thus, it is legislative in character. Then, because the final rule bears almost no resemblance in manner or kind to the proposed rule, the final rule fails the logical outgrowth test and violates the APA. This was huge because the Fifth Circuit stated that the ATF and their rule on pistol braces goes beyond their authority. Also, there was the fact that the original presented worksheet 4999 in the proposed rule had a bunch of defined point systems and requirements. In that original proposed rule, they had that worksheet, and then in the final rule, they completely scrapped the worksheet. And what the Fifth Circuit said is that violated the APA because it did not adhere to the logical outgrowth test. The Fifth Circuit also rejected the ATF's claims that the pistol brace rule is merely interpretive in nature. Instead, they said it was in fact legislative in nature. So what does that mean? Well, the Fifth Circuit came to the conclusion that they believe Judge O'Connor committed an error by denying the original request for a preliminary injunction. What is also important about that decision is the Fifth Circuit found that the hardest part of the injunction standard was in fact met by the plaintiffs. The factors that must be met to win an injunction is the likelihood of success on the merits, irreparable harm, balance of the harms, and then also the public's interest, and the consideration and the balance of that needs to be taken into account. The hardest of those factors to meet is in fact the likelihood of success on the merits. Often, if a plaintiff can show that they have a likelihood of success on the merits, they will ultimately win the injunction and oftentimes also win the entire case. Now, in this case, the Fifth Circuit said that the plaintiffs did show a likelihood of success on the merits. Therefore, they remanded the case back down to Judge O'Connor for him to redecide the injunction but all he is going to look at is the remaining factors for the injunction. And the plaintiffs have already had the hardest factor of that test, likelihood of success on the merits, granted to them by the Fifth Circuit. We also just received the plaintiff's supplemental brief submitted to Judge O'Connor, where they argued that they have met all the remaining factors to be granted an injunction. But also they are arguing for a nationwide injunction to be granted against the pistol brace rule. In the plaintiff's briefs, they argued that the Fifth Circuit held that the plaintiffs have a substantial likelihood of success on the merits of their claim that the final rule violates the Administrative Procedures Act. As the court recognized, there is authority that the first factor, likelihood of success on the merits, is the most important of the preliminary injunction factors. They go on to argue that when looking at the remaining factors, everything weighs heavily in the favor of the plaintiffs. They argue that the injury to the plaintiffs outweighs the injury to the government because an injunction will simply keep things the way that they are and that the way they've been for decades before the ATF put in place their new pistol brace rule. Then the plaintiffs go on to argue that the scope of the relief that should be granted by Judge O'Connor should not be limited, but instead should be a nationwide injunction. But even if the court finds that a nationwide injunction should not be granted, the scope of this injunction should be at least what the Fifth Circuit granted, where it's protecting the individual plaintiffs and then also members and memberships like FPCs. In their briefs, the plaintiffs state that, finally, the circumstances here require a universal injunction that prevents the defendants from enforcing the final rule. Because this case arises under the APA, this court has the express statutory authority to issue all necessary and appropriate process to preserve status or rights depending conclusion of the review procedures. Enjoining the final rule to preserve the status quo prior to its publication is essential to give the parties relief from the harm caused by the final rule. Plaintiff Maximum Defense sells or, prior to the publication of the final rule, sold braced pistols or stabilizing braces into all 50 states. Given the extensive reach of the final rule across all steps of the commercial chain, the market disruption caused by the final rule will not truly ease unless and until the final rule is universally enjoined across the country. They go on to say that at a minimum, the scope of the injunction should continue at least as far as that instituted by the Fifth Circuit, enjoining enforcement of the final rule against the individual plaintiffs and their families, Maximum Defense and its customers, including all direct consumer purchasers and intermediaries, distributors, dealers, retailers, and everyone within the chain of the sales. They go on to say that also all FEC's active members should be protected as well. So that's what's currently going on in the ATF pistol brace lawsuit, the Mock v. Garland case. This case is back in the hands of Judge O'Connor, and he's required to issue an injunction, which was 60 days from the date at which the Fifth Circuit issued their order. The Fifth Circuit already granted the hardest part of the injunction test to the plaintiffs, so now Judge O'Connor is simply looking at the remaining factors of what scope of the injunction should be granted and all those remaining factors for whether or not an injunction should be granted. But like I said, the weightiest part of that test is the likelihood of success on the merits, and there is plenty of precedent that says that oftentimes if a likelihood of success is present, then really all the other factors should also go in the way of the plaintiffs. Now, I know some people are going to ask, okay, what's the current status? Current status is that you can still have pistol braces on a AR pistol, AK pistol, as long as you are protected by the injunction that has been granted to these memberships, FBC, GOA, SAF, and some others. So the status quo for the most part has remained the same, that members are covered. It's likely that that's going to happen and continue forward at the very least. And now the fight is to expand that scope, to expand the injunctions, and ultimately get a nationwide injunction. So we will see what Judge O'Connor will do in this case. Again, he had 60 days from the date that the Fifth Circuit issued their order. He has to issue that decision soon. And of course, if we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, or as all of you OGs know, fuel Al Gore's rhythm. It signals to the YouTube algorithm that you guys enjoy these types of videos, that you want to spread these types of YouTube videos out to more people. Subscribing is one of those main factors where it signals the algorithm and sends it out to more people. So thank you guys so much for all of your support. And as always, don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.